Hello students. The topic for discussion in this presentation is trespass to person. As we start the topic, let us first look at the definition to chalk out the essentials of what constitutes a trespass to person. The definition says, any interference, however slight, with a person's elementary civil right to security of person and self-determination in relation to his own body constitutes trespass to person. So the essentials given in this definition are a however slight interference with a person's elementary right of security of persons and self-determination. So the essence of the tort of trespass to person is that it is a means to protect a person's security, liberty, and well-being. It is based on a principle that any direct invasion of a protected interest from a positive act is actionable subject to justification. So any direct invasion of a protected interest is actionable, but it is subject to certain justifications. Now what these justifications are will be dealt with subsequently. One important point to be kept in mind is that a tort of trespass to person is distinct from tort of negligence because any direct and intentional acts are dealt with under the tort of trespass. However, unintentional and indirect acts are dealt with under negligence. So what is of essence here is that intention plays a very big role in the tort of trespass, and we will see subsequently how intention plays a role in all the different kinds of trespass we study. Trespass to person is majorly divided into three categories, that is, assault, battery, and false imprisonment. Let us begin with a discussion of what assault is. Assault is defined as an attempt or a threat to do a corporal hurt to another coupled with an apparent presentability and intention to do the act. There are a few essentials which we should chalk out and bring it out from the definition. The first is an attempt or a threat to do a corporal hurt. So it is essential that it should be an attempt or a threat and not an actual act of the hurt. Second is that it should be a corporal hurt. Now what a corporal hurt is, a hurt to the body. So anybody's physical being. It should be coupled with an apparent present ability and intention to do the act. And apparent ability. So the act should be such that if it proceeds will result in a harm to that person. And the person intends to cause that harm to another. Let's take an example to understand this better. A person X raises a pistol at person Y from a point blank range. Now, the person does not shoot the other person. X does not shoot Y, he only raises the pistol in anger. This amounts to assault because it meets all the essentials of assault. There is a threat to do a physical harm with the apparent ability. If he fires, X fires the trigger, Y will be hurt. So here he is capable of doing that hurt, right? And there is an intention to hurt because he is in anger and he pulls the pistol at him. Next is what is essential to remember, that the contact, there need not be an actual contact with the person. You can also commit an assault from a distance. In order to better understand the tort of assault, let us understand its essentials. The first is that the plaintiff must prove that there was some gesture or preparation which constituted a threat of force. So, it must be proved by the plaintiff that the defendant did some gesture or did certain preparation. For example, the defendant raised the gun towards the plaintiff, or the defendant raised his hand to beat the plaintiff, or the plaintiff was chased by the defendant in anger to hurt him. So there was a gesture or a preparation which constituted a threat of force. The second is that the gesture or action must cause a reasonable apprehension of force. Now, not every action amounts to assault. Only those acts which cause an apprehension in the mind of the plaintiff that there might be some force used against him or some harm done to him will those acts be called assaults. So, for example, if I normally run towards a person, it will not be an assault. But if in anger I raise an object and run towards him, signifying that I would hurt him with the object, that would be an assault, right? The next is that there must be an intention which must be present. Now, what do you mean by this? The intention here is the intention to cause the hurt or the intention to the threat of force. So it must be intended by the defendant to threaten or to cause that reasonable apprehension that there might be forced use against the plaintiff. When I pull the trigger, pull the gun, I am creating an apprehension in the mind of the plaintiff that yes, I might hurt him. My intention is to scare him, right? So these are the three essentials which are necessary to prove that there is an assault which is constituted. We've understood that intention is very important in the tort of assault. However, mere intention will not have any effect. It has to be coupled with an act. You might have an intention to hurt somebody, but if you do not do an overt act to show that yes, you might hurt somebody, the tort is not accomplished. So, for example, I might have a pistol in my hand. However, until I raise it towards the other person, there is no assault which is committed. I might have it in my hand with the intention to threaten the other person, but I have to do an act to show that I want to threaten that person. Until that act is done, there will be no means of accomplishing the tort and the tort will not be complete. Now, another point to be kept in mind is that there must be, and or in order to constitute an assault, there must be a means of carrying the threat into effect. Mere words of saying, I will hit you, will not be an assault. But saying, I will hit you by showing a fist towards the other person with the intention or an act that, yes, if I move that fist any further, it might hurt you, is an assault, right? So there must be an act, means of carrying the threat into effect. Till that is not present, an assault is not said to be committed. Let us look at certain case laws in order to understand what the tort of assault essentially constitutes. The first is Tuberville versus Savage. Here, the person raised his hand and kept it on a sword and said, if it was not assize time, I would not take such language from you. A case was brought for assault against him, saying that he threatened the other person to commit some harm to him. It was held that this is not assault. The reason being that there was no immediate or imminent threat which was intended against the person. He had said that if it was not this time, I would not have taken such language from you. It did not in any way show that he would have hurt him or there was any immediate or imminent danger to him. So hence, here the court held that there was no case of assault which was made. From this case, a very important principle is taken out that in case of assault, there should be some imminent threat or some threat which is immediately done to that person. And there should be some means to carry out that threat. Merely saying something does not constitute an assault if there is no intention that the person would immediately hurt the other person. So here, immediately hurting or an immediate threat of force is essential to constitute a assault. The next case is Reed versus Cocker. What happened in this case was that the defendant came to the plaintiff and told him to leave his premises where the plaintiff in fact carried on his business. Now the plaintiff refused to do so. On being refused, the defendant brought in certain men who threatened the plaintiff, saying that they would break his neck if he does not leave the premises. The plaintiff got scared and he left the premises and brought a claim for assault. In this case, The plaintiff was successful in bringing the case of assault, and here the court held that the facts here clearly showed that the defendant was guilty of assault. There was a threat of violence exhibiting an intent to assault and the ability to carry the threat into execution. So, what the court held was that there was a threat and there was an immediate ability to carry out the threat into effect and thus hurt the plaintiff. And hence, a case of assault was made against the defendants. The next case for discussion is Stephen versus Mayers. In this case, both the plaintiff and the defendant were sitting at a meeting. The plaintiff was the chairman at the meeting. The meeting had some angry discussions, and the defendant got very furious and he started interrupting the meeting. On a vote of the majority people, it was decided that the defendant should leave the meeting, and the chairman of the meeting, being the plaintiff, ordered the defendant to move out. The defendant raised a fist at the plaintiff in an action to hit him, but was stopped. A case was brought against him by the plaintiff for assault, saying that he intended to hurt and threatened to hurt the plaintiff. The defendant took the plea that there were 6-7 people sitting between the plaintiff and the defendant, and there was no possibility that the defendant could have hurt the plaintiff. However, the court held that there was imminent threat which could be brought into effect had he hit the plaintiff then, and thus the defendant was held liable for assault. Having understood what assault is, let's move on to understand what battery is. Battery is basically one step ahead of assault, or what happens after an assault. So, it is an intentional and direct application of any physical force to the person of another. It is the actual striking of another person or touching him. So, what battery essentially means is that the use of force. Assault meant the threat to use of force or the attempt to use of force. Battery is the actual striking or the actual use of force. Here, the plaintiff has to prove that force was used without any lawful justification. So, what happens is, or what can be understood is, that a battery occurs after an assault. For example, if you pull a chair when somebody is sitting, the moment you pull a chair, it is assault because you pull it to threaten him that he would fall. Till the moment he falls on the ground, it is an assault. The moment he falls, it becomes a battery because it is the actual use of it. You raise a pistol to somebody's head, that's an assault. If you pull it and you hurt the person, it becomes a battery. So battery is the actual use of force, right? Now you should remember that not every laying of hands and not every touch or every use of hands on the other person is battery. What is battery is that somebody intentionally uses some force. This can be by various means. For example, it can be by the projection of some heat, light, noise or vapor to another person so as to cause any physical injury or discomfort. It can also be the forcefully taking away of a thing from somebody else. It can also be when you bring any material object to contact of another person. So the use of heat, light, force, vapor to cause injury can be, for example, you bring in steam intentionally to touch that person's hand so that he burns. You forcefully pull something out of somebody's hands, for example, a ball, so that he gets hurt in the process. Or, for example, you throw water, hot water on somebody so that he gets hurt. These are examples of battery, right? What is essential and what the test is, the use of force without a lawful justification. So if you have a justification to do what you have done, you have not committed a battery. The next case law is Wilson vs. Pringle. In this case, both the plaintiff and the defendant were schoolboys. They were running around in the school corridors and it resulted in the plaintiff falling and being injured. The defendant argued that there was no battery as there was no deliberate touching with hostility which was involved, and there was no intent to inflict any injury. It was merely a playing around of the boys. However, the plaintiff argued that there merely had to be an intentional touching. The court held that battery involved intentional touching with hostility, but no intention to cause injury. The court considered whether a better test would be to implied consent or a test based on how common the actions are in daily life. But the court ultimately held that hostile touching would be battery. Let us now look at certain case laws in order to better understand the concept of battery. The first case is Stanley versus Powell. In this case, both Stanley and Powell went for shooting into a jungle. Powell aimed at a bird and fired through his gun. However, the bullet through his gun hit a tree and came back and hit Stanley. Stanley got wounded in this process. A case of battery was brought, however, it was held that there was no intention to hurt and there was no threat which was intentionally applied on Stanley. And it was considered to be a case of inevitable accident, and Powell was released and no liability was put on him. Having understood the elements of assault and battery, let us look at what the elements which are required to be proved by a plaintiff in the court of law to prove his case of assault and battery. First, what needs to be proved in case of assault? First is that there has to be an attempt or a threat by the defendant to apply force to the plaintiff, right? The next is that there must be a reasonable apprehension of instant battery to the plaintiff. Now, there has to be an apparent present ability of the defendant to execute his threat of force. What do you mean by this is that it should be in such a manner that if the act proceeds, the assault becomes battery. For example, if you raise a bullet towards somebody, a gun towards somebody, you have an apparent ability that if you pull the trigger, you will commit battery. And there should be intention to effect his purpose. So the person has to show that he has an intent to effect and to bring about his purpose. These are all essentials which need to be proved for assault. There are two additional requirements which need to be proved in case of battery. The first is that there is an actual application of force to him. Why? Because assault is an apparent threat and battery is the application of that threat or the application of force. And next is that the same was without any lawful justification on the part of the defendant. So both for battery and assault, there need not be any lawful justification. If there is a lawful justification on the part of the person, they are exempted from that, right? Having understood the essentials of assault and battery, the principles on which they are based, and the elements which are needed to be proved in a court of law, which to prove battery and assault and the case laws related, we come to the conclusion of the discussion here. So let's conclude by summing up that assault is an attempt to commit a battery or is an inchoate battery, and battery is an assault consummated or the actual use of force. Now, generally people say that a battery is always preceded by an assault. That is, first an assault is done and then a battery is done. However, this is not always true. For example, if you hit somebody from behind, there is no assault committed here because the person did not feel any apparent threat or an attempt of the use of force. The person did not even realize that you're going to hit him. Assault is when you threaten a person to use force, right? However, in case of hitting a person from behind, you do not use that force to threaten him. You straight away commit a battery without an assault being committed then. Similarly, not every assault is ended in a battery. You do not always hit a person after threatening him to be hit, right? So this is a distinction which you should keep in mind. We have concluded the session on battery and assault. If you have any doubt, you can mail me on my mail ID, that is shruti@mpdnlu.ac.in, and I will be there to help you.